So good morning, everybody. Thank you guys for being here. We are just going to wait about one more minute before we get started. So while we wait, I'll introduce myself. My name is Angel Orozco, and I am your sales executive for Fidelity National Title. And with me today, I have the amazing Renee Lowe, who is a senior escrow officer and the branch manager for her branch downtown San Jose. And she is highly connected to the Silicon City office. I know she works with a ton of agents in there. So if you ask around, you guys will know her. She's highly experienced. She's one of our top EOs. And she's kind enough today to give us her time, even though she's so busy. So I'd like to welcome Renee. And if you want to just go ahead and introduce yourself, Renee, please feel free to.
Absolutely. My name is Renee Lowe. I am an escrow officer here with Fidelity. I've been in the escrow industry since 2000. I started my escrow career in Arizona and moved to California in 2004. I've been here ever since. I love what I do. I love helping agents grow and also educating and making sure all the buyers and sellers are also aware of any questions they may have. So I love what I do. I love seeing a lot of newer agents grow. I think that for me is one of the biggest thrives in my career is working with an agent when they're brand new, and then in a couple of years seeing them grow into top producing agents. That's always great to see. And any question, whether it's small or big, I never am afraid to answer it. So even afterwards, if you have questions, you can reach out to Angel or myself, and I'd be happy to answer them, even if it's not a transaction that I'm working on.
Thank you. So I'll be leaving both of our contact information for all of you guys. You guys are always welcome to reach out to us. Our main goal is to be a resource to you. So with that being said, we're going to be going over how to read a preliminary title report. We encourage your participation. And if you have any questions, please feel free to ask away, because the more interactive everybody is, the more we are going to learn from each other. So Renee, if you want to go ahead and start.
Absolutely. So what is a preliminary title report? A preliminary title report is basically an offer to issue title insurance policy. What that is it's going to show you any items that are going to be on the property that need to be accepted by your buyer or things that are going to be removed. It is not the final title policy. It is just a preliminary title report. And the one thing, and I'm probably going to mention it a lot throughout this presentation, and it's so crucial and it's so important that you review the preliminary title report on all your transactions, whether you have a buyer or a seller, because there are things that are going to have to stay on the preliminary title report that cannot be removed, that could affect your clients, especially a buyer, that may affect their taxes, or something that's subject that needs to stay on a property. So it's really important that you review it. If you have questions, ask your title officer, your escrow officer. And if you're not getting any help, reach out to a valued resource that you may have. It's just, I can't stress the importance enough of the importance of reviewing the title report, no matter if you think it's a simple report or not. When should you order a preliminary title report? We always recommend ordering a preliminary title report as soon as possible. If you are getting a listing, even if the listing is not going to go onto the market for 2 to 3 months, it's really important to order that preliminary title report right away. The reason we recommend that is because the title report is going to show you anything that may be hindering the property. It's going to show you any liens, any easements, and who the legal owner is of the property. That's why it's really important that you order the title report as soon as possible. And the good thing is we can always date down the title report. So if you order a title report today and know that you're not going to be putting it onto the market for 2 to 3 months, when you're getting ready to go onto market, you can just send your escrow officer an email and ask them to update the preliminary title report. It's really quick and easy to do. And just so you know, we don't charge you if something happens and the transaction doesn't close. We're not going to charge for a preliminary title report. So some people get asked that question a lot. Do I have to pay for it? If the deal doesn't close, there's no fee for it. So how do we prepare a title report? Well, the preliminary title report is done by our title department. Once the escrow is opened, we send the order to our title team. Our title team is going to pool all transactions on the property from inception of the property. They're going to make sure all liens have been released. They're going to make sure all deeds have been insured and making sure that everything is what it should be. This can take time, especially if you are working on a property that's very old and has maybe been in a family for an extended amount of time, and it takes a lot of what we call back research. Normally, we can get our prelims out within 3 days. If you aren't seeing a prelim within 3 days, then it's reach out to your escrow officer, because it could be that there's something more that they're searching on it and they can give you a better time frame. If you need a rush, if you know that this particular title report, you need it as soon as possible because you're concerned that there might be something you want to make sure is correct, it's important you just let the escrow officer know, hey, can you do a rush on this? And we can definitely try to get it to you within 24 hours. I have had that happen where title was able to pull it for us, as long as there's not a lot of back research. So we can always rush if needed. Just reach out to your escrow officer or your sales rep and let them know, hey, I really need this rushed, and we can do the best that we can. What is in your title report? It's really important that you know what's going to be in. Sorry. It's really important to know what's going to be in your title report. The first thing that the title report is going to show is the estate, the interest is covered. Now, when we say estate, that means the property. Who is the owner of the property? That is the first thing that we're going to look at. I'm sorry, let me go back up. The estate is the property itself. So when we say the word estate, that means the property. So 123 Main Street, in this case, would be what we're looking for. It's really important that you make sure that the property address is correct. The reason we say that is if you say 123 Main Street, but really it should be 456 Main Street, and the title report has the incorrect address, that's the report that we're going to be working with. The next thing that's going to show you is the owner of the estate or interest. This is going to show you who the legal owner of record is. It's going to show you, is it an individual? Is it a trust? Is it an LLC? Is it a corporation? Is it a bank? That's going to be important to look at too, because if you're dealing with a seller of the property and they say that it's Joe Smith and you're dealing with Henry Jones, you might not be dealing with the correct owner of the property. The next thing that's going to show is the parcel number. The parcel number is going to be what is used as the tax records of the property. If you have a parcel or a property that has more than one parcel, it's going to be important that you make sure that the preliminary title report has all of the parcels that are listed in there. Also, it's important to make sure that your client wants to sell all the parcels. If they only want to sell parcel 1 and not parcel 2, if we're able to separate them, then we can do that. So it's really important to look at that as well. The next page is going to talk about exceptions, liens, encumbrances. Exceptions are items that will always stay on a title report. Liens are going to be things that have to be paid or satisfied at closing. And then encumbrances are things that are encumbering the property, like easements or things like that. And then we have in the notes section. The notes section will just say basically any notes. We're going to go through a prelim, so we're going to go through each page of the prelim so we can show you where these are at. And then once we close a transaction, we go off the preliminary title report, and we will, anything that's being removed will not be on the final title policy that's issued at closing. So now what we're going to do is we're going to go page by page through a preliminary title report. And please, if you have any questions at all as we go through this, just let us know, because we want you to be comfortable and understand what you are seeing. So the very first page of all preliminary title reports is just going to be just that. It's going to tell you what you're receiving. It's telling you that this is a preliminary title report, and it's not a binder or commitment to issue title insurance. That is issued once the transaction is closed and the title policy is paid for. We issue no liability in a preliminary title report. So you can't take a preliminary title report and say, well, the preliminary title report said this. That's not your final policy. So that's just what it is. It's a preliminary report saying that we are desired to issue title insurance, and we will do that at the end. This next page is going to talk about it's going to go step by step through your title. So the very first thing right here, you see at the top, is your title officer. Your title officer is the person that is behind the scenes. You're never really going to ever talk to a title officer. You're going to talk to the escrow officer. So here, your escrow officer would be listed. Your escrow number is here. And then if we have the loan number, we would put it here. We don't necessarily have to have the loan number. It's just if we have it, a lot of lenders do like us to put it there. Here is always going to be our listing agent. So here we would put Keller Williams, and then it would have the address and the agent's name. So it's really important. We like to make sure that we address it to our agents as well. This right here, we're property address. So here's where we're going to put the property address, property, city, and state. We do not put zip codes on our preliminary title reports. A lot of times people will ask us to put zip codes on there, and we do not insure zip codes. So if you get pushback from, let's say, a lender on your buyer saying that they need a zip code on the preliminary title report, just know that we cannot do that because of the title insurance does not insure zip codes. The property address is going to be what is based on the tax record. So for instance, if your property, there's some areas where the mailing address might be Campbell, but the property is actually in the city of San Jose. This is based off the tax record and not the mailing address. The next thing is effective date. What your effective date is that is the date our title plan is up to date. It's never going to be a current date. So like today, our preliminary title reports are coming out with, I want to say, around August 26th. Always know that that date is as far as we've been able to search the property. So if your client has just recorded something today, it's going to take about a week for it to show. Anytime you ask for an update, that effective date is going to be updated. This next part right here is going to talk about the title insurance policies we're going to issue. In this case, the prelim, for example, we are issuing an owner's title insurance policy and a lender's title insurance policy. If you just have an owner's policy, it would be listed here. If you just had a loan policy, it would just list one of the two. And these, again, these are the anticipated policies and not the final policies. This next part, we talk about the estate. The estate is the owner of the property. Oops, sorry. This, I believe, actually, let me look at something. Sorry. I apologize. I wanted to make sure. So the estate, that's actually going to say what type it is. Most of our properties are going to be what we call a fee property, a fee simple. That's the highest level of the estate. It could say land, it could say inheritable, but 90% of these are going to say the word fee here. This also, if you deal with co-ops, this will say, instead of a fee, it will say co-op. That's more if you're dealing with a property in San Francisco, where they have, or if you do stuff at Stanford, I believe those are also co-ops. So now we're going to go up to the top over here again. And then this right here is going to reference your escrow number again, or the title number. You really don't have to worry about these numbers right here. This is more for escrow end of things. The most important thing on a prelim that you want when it comes to numbers is your escrow number, because that's how we're going to identify that file in our system, or the property address. The next item over here we're going to talk about is item number 2. Item number 2 on the prelim is going to talk about the owner of record. So this is going to tell you who is the legal owner of the record of the property. Now, if it says Sally Smith and Henry Smith, husband and wife, and you know that one of the parties happens to unfortunately be deceased, that's okay. We would rectify that through our closing. The most important thing is to make sure that the party you are dealing with is the legal owner listed there. If you see this right here and it says subject to an item is going to mean that there was a document recorded throughout the transaction that is a uninsured deed, and we're going to just need information to show that that was a legal document that was recorded and no fraud or any money is due to that party. Next item, letter number 3, that is going to be your exhibit or your legal description. Now, it's always going to say, for fidelity prelims, it's always going to say, see Exhibit A attached here to and made a part hereof. What that's basically saying is we're not going to put the legal description in this little part right here. We're going to attach it on the very next page, and that's going to be your legal description. So that always is going to show you, because of the wording, we have to just let everybody know it's going to be attached to the next page.
Hey, Renee. So you kind of mentioned some red flag, that red flag for number 2. What are some other red flags that we should look out for in number 1 and number 2?
So number 1, if it's anything other than a fee, we really want to take a deep dive into it to see what kind of land is being sold. Is there any, do we need to get approvals? So it's really important that if you see anything other than a fee in there, that we're making sure, especially if it's a co-op or a land lease, that we're making sure that the transfer is able to be done and what needs to be done to approve that transfer. Number 2, I think the biggest red flag is that when you are showing the title vested in somebody other than the party you're dealing with, really find out how they're involved in the transaction. Because, you know, when you have a party that's a trustee, when your property is in a trust, which we'll show here, it could just simply be that we're going to need to get documents that a successor trustee is selling the property. However, if it says Joe Smith and Betty Smith, husband and wife, but their son Peter Smith is the one selling the property because both of the parents have passed away, and they use the word, the will says I get the property, that is kind of a huge red flag that, well, we're going to probably need to go through probate. And the reason is because a will is not a document that's going to allow us to transfer a title. So anytime somebody's vested in other than individuals, and if they're vested anything other than a trust, then if anybody is acting upon the owners, we want to find out the ownership we want to make sure that we know their interest and how they're involved in the property. Also, if you're dealing with an elderly couple, and somebody is saying, oh, I'm taking care of my mom, all my mom's finances, and she wants me to do all this for her, really want to make sure that there's some sort of communication with the true owner to make sure that there's no elderly abuse or elder fraud being done in the situation. I know all agents are really good at detecting this stuff. Just make sure that if you're dealing with anybody other than who it says there, that you're really diving into why that person's involved in the transaction. Does that help?
Yes, it does. So actually recently I saw something where the title report said something like, person A and person B as husband and wife, and there was person C and D, also husband and wife as joint tenants. And C and D are basically A and B's parents who helped them qualify for the loan for this home. And so when they were selling it, I wasn't sure, like, oh, who should be involved in signing the papers? Do they all have to sign it, or?
Yeah, you
right.
would want them all, because they're all going to have to sell the property. They're all considered owners on the property. So they're all going to want to be involved in the sale. Now, when it comes time to sign the paperwork, seller A and B can get 100% of the proceeds, but C and D have to know that the sale of the property is happening, especially they might be owed some money and A and B are not trying to get that to them. So while A and B might get to make all the decisions, C and D still need to at least sign the escrow paperwork. I believe I've been seeing lately, I have had that come up recently a few times actually, and they've had to do addendums to the contract, adding those sellers to the contract because they are legal owners of the property. I had recently a file where it was parents on title. They added their son just in case something happened to them. They were selling the property, but they didn't want their son to have anything to do with the property. And they wanted him to do a grant deed to grant off of the property. And I had to make sure that they were very much aware that's a taxable event. And the sellers had to pay double transfer tax because now they have to pay transfer tax on the sale of the property, but they also have to pay transfer tax to remove their son from title. So they were very adamant that's how they wanted to do it. So they just ended up paying extra transfer tax to the county. That's, we let the seller make the choice of how they want to structure it as far as that goes. They just didn't want their son to be involved in any of the contract stuff. So if that is the type of case where the parents don't want to be involved in anything, we would still need to get them to do a grant deed, and the seller would just need to know that they're going to have to pay double transfer tax.
Got it. Thank you, Renee.
You're welcome. The next part was talking about the legal description. So here is our legal description. The legal description is going to show you how the county knows that that property is. So I'm going to point out a couple of things. So in our description right here, we're talking about a lot. What a lot is a lot is where somebody owns the land that the property is located on. The most important thing that I want to say when we talk about lot, and this is one of the biggest questions that we get as an escrow officer, and people are asking about legal descriptions. We all know that some of these newer developments that are townhomes that, they don't have anybody above them, they don't have anybody below them, they just share a wall. Back in the before pre-2000, I would say, all of those when it was a townhouse, it was considered a PUD or a lot. If you see the word units, so instead where that word lot is, if you see the word unit, that means that the county records show that this is zoned as a condo, a condominium, which means that your buyer of the property or seller of the property do not own the land, they just own the airspace within the walls. So it's really important because it can affect lending, that if you see the word unit, that you know that you're dealing with what's considered a condo zoned project. And we get that question even afterwards. I actually just had a guy doing a refinance, and he got really upset because he was under the impression that he owned a lot, and he actually didn't. It was zoned a condo, and he was very upset. So it's kind of important that you know what type of property that you're dealing with when you're selling that property or buying the property. So at the top here, we're going to talk about the land referred to here and below is situated in the city of, and this is where it's going to be the city. Now there's a pocket in the city of San Jose that you're going to see. It says the land referenced, land referred to here and below is situated in the undeveloped or unincorporated area of the county of Santa Clara, state of California. If you have a property that is in unincorporated San Jose, you do not pay city transfer tax. So it's really important that you look at this right here. And it also goes back to your address that shows on that first page of the prelim, because your address is going to show you this, it's going to show you the tax address. So it's not going to show mailing. So if this says the city of San Jose, but the mailing address is city of Campbell, they're still going to have to pay transfer tax based on whatever city shows here. So just keep in mind, it's not going to be the mailing address, it's the tax address. So then we're going to go here. This is going to give you the description. So lot 1, 2, 3 of block B, this is where if they want to go pull anything at the county records, they can say, oh, I own lot 1, 2, 3 block B of Sunnyside Acres, filed in book number, page number. This is where you're going to be able to find the plat map to do with your particular unit. Now, if we're dealing with a condo, if you're dealing, this is a lot, I see this a lot in downtown San Jose, because I do a lot of units down here. If you know that the particular unit has a deeded parking space, a deeded storage unit, make sure that those are all listed in your legal description. And the reason I bring that up is that we have had situations in the past where someone's going to sell their property and somewhere in the chain of title, the parking space had been eliminated or the storage space had been eliminated. And it causes issues because it's now no longer a record to that particular unit. There's one particular complex in downtown San Jose that I do a lot of units in. And I think we've had to fix probably at least half of the units because over time the legal had been messed up just through refinances or purchases with other title companies. So it's really important if you are dealing with a condo and they say it is a deeded, that's the most important word. If they say deeded parking space or deeded storage space, that you're able to identify on your legal description what that number is. And if it doesn't show on there, we want to make sure that we're having the title officer research and update that, because we want to make sure your client is getting that true legal description that they should be getting. Now we're going to get into the part of the preliminary title work that talks about exceptions and exclusions. Exceptions are items on a preliminary title report that are going to stay, and exclusions are things that can be removed. So in this particular part, we're going to talk about taxes. Item number 1 is always going to stay. And the reason that's always going to stay in a preliminary title report is because we're talking about the current fiscal year that is coming up. So for instance, on your prelims today, you're going to see this wording with fiscal year 2021-2022. The next item is going to show you the current assessments. So in this case, the property taxes, we're going to use 2007 to 2008. This particular owner has already paid their first installment, but their second installment is still outstanding. In this case, we're going to pretend like it's not past due yet. If it was past due, it would tell us past due and then penalty amount. This is a flag to escrow that we need to make sure that we're paying the taxes. This item would not show on a final title policy if it's being paid in escrow. If for some reason we're told don't pay the taxes, the buyer's going to take care of it, then this item would actually show on a final title policy. It's also going to show you the value that the county is currently assessing it at. So if your client wants to know, hey, how much are my taxes going to go up? This will give you an idea of what is currently assessed, so you may be able to help them figure what their potential assessment may be. The exemption, this is that the primary homeowner exemption that you get when you have it, when you live there as a primary property. So they get a $7,000 exemption off of the value of the property. So it shows you here, if it doesn't show an exemption, that just is a flag that it was an investment property at some point for that particular person. This particular example, that our seller has some past due taxes. It's really important that if you see past due taxes in there, that you're making sure that the escrow is taking care of those past due taxes, because we don't want that to fall onto your buyer. If it is missed, if a title or an escrow officer misses paying those taxes, then you definitely would reach out to them after the closing because they would want to take care of that.
Renee, will it be up to the seller to pay that if the escrow officer does realize that they're past due?
Yeah, so what would happen in this case, if the escrow officer didn't pay it for some reason, and it was disclosed, then the escrow company title officer, the title company, would then be liable to pay it, but then we would go back against to the seller to make sure that it's paid back to us. If we have to file small claims against them or something, but ultimately it would be the responsibility of the escrow company, title company, if it's disclosed and not paid, because our job as an escrow company is to issue clear title to your buyers, and we wouldn't be able to do that if it wasn't paid in full.
So if you did notice that it was unpaid, you would just have the seller pay before close of escrow, correct?
Exactly. And if the seller tells us, I've already paid it, oh, I just paid the check, I just mailed a check, it hasn't posted yet, well, we're going to tell them, we understand that. Unfortunately, we're going to have to hold that amount of money until that clears. And then we're going to continue to check it on a daily basis. If within 30 days it hasn't cleared, then we're going to have to pay that to this county that it's due, because we want to clear that title, and then the county can refund back to the seller if need be.
Great, thank you. And then I have one more question here, if you don't mind me interrupting. Yeah. Will the escrow officer look out for these things as well and make sure of any red flags? Or is it the responsibility of the realtor?
No, escrow will need to make sure, that's our job. Our job is to make sure that we're passing on free and clear title to the clients. We're neutral, so if the seller is disputing something, well, we'll try to understand it. We have to also understand that we are issuing the title insurance policy, so we have to make sure we have proof that something's been cleared. But it's 100% an escrow officer should be reviewing all of this. I mean, I'll speak on myself. As soon as anytime I open a file, a prelim comes in, I look through it just to look for any red flags. If I don't see any red flags, then I just wait until we go in contract and then order payoffs. If for some reason, I always also send it to the real estate agent, and the real estate agent, hopefully will look it over as well to provide any insight that they may have. A lot of times we're strangers to the sellers and buyers. They really don't understand who we are and our role in the transaction. So they get kind of leery about providing us information. They feel more comfortable with our trusted real estate agent and providing that information to them. So we sometimes rely on our real estate agents, clients, to help us communicate with the sellers or buyers to get information if needed. But it would be the escrow's responsibility to reach out to the county to get the amounts that are due. So for instance, on this past due tax down here below, it would be our responsibility to reach out to, in this case, we're going to say the county of Santa Clara, to make sure we have the correct amount that we're paying to them.
Great, thank you, Renee.
You're welcome. So then the next page, we're going to talk about this. We're still talking about some taxes. So number 4, our wonderful Mello Roos taxes. Mello Roos taxes are something that has been approved on a property that is part of the normal tax bill, but is a special tax. These can be anything from libraries to fire stations to police stations. However, and I only bring this up because I just had this happen last year. So we all know about wonderful hero loans. And the hero loans are loans that somebody can get to do energy efficiency on the property. Normally they record it as a separate lien on the property. However, they've started to record them as Mello Rooses. And Mello Rooses cannot be prepaid. So if you see a Mello Roos on the prelim, it's going to be really important that your buyer understands that that Mello Roos is part of the normal tax bill and it cannot be prepaid. So in this case, the file that I have, the client's tax bill is about $8,000 more than it should be because of the Mello Roos that was disclosed to them. And we disclosed it to them at the signing. They just didn't understand it. And so now a year later, why are my taxes so high? So just pay attention to this and really make sure that your client understands that a Mello Roos will follow the property. Now, if they sell the property, they don't prepay anything. It just continues on to the next owners of the property. And it's always part of the normal tax bill. So it's not a separate tax bill. It's not a separate bill they're going to get. It's all in their normal tax bill paid twice a year.
Renee, does it ever say how much specifically is the Mello Roos within the overall tax bill?
Mm-hmm. Sometimes it will. We can also pull the tax certification or tax roll, which will show that as well. But sometimes it will say the amount of 19,000 or however much it is. The problem with the Mello Roos is that we can't. So if you see up here, you see like this recorded document number. Some people ask us to get that document for them. That document is really hard for us to send out because it can be thousands and thousands of pages. Depending on how many houses and units are part of that Mello Roos, it's really hard to get that information. I get a copy of that document without literally printing it out and hand delivering it to you because it's just so big.
Do Mello Roos taxes ever expire? Do they have an expiration date, or
Yeah,
is it forever?
They do. They there's a term on them, so it'll tell you the last payment date on. I believe it shows it. I want to say it shows it on the tax roll. I would have to go look at a tax roll to see, but it's always we're always able to find out how long that Mello Roos is for. And we can always look at the recorded document. It's just really hard to send that recorded document out because it's so big.
Got it. Thank you.
The next item, number 5, this is supplemental taxes. We are always going to show this on a sale file because we all know that your buyer is going to have a supplemental tax coming up. And we just want to make sure that they are aware that the supplemental tax bill will be coming to them based on the county reassessing the property and that it's a different assessment. The next item we have here is 6 and 7. These are easements. Easements are things that cannot be removed from the property. They can be anything from utility poles, pipeline, roadways, sewers, anything that's dedicated for use that needs servicing. So for instance, I've learned more about easements in the last couple of weeks than I ever thought I would in my life, only because where I live in a townhouse, which is zoned a lot. PG&E has an easement on our property. Now PG&E is installing posts in our driveways to protect their gas meters, which are now taking away use of driveways. So we've been going back and forth with them, but they're basically, every time we go to them, they're like, well, we have this easement on the property. We have the right to do what we need to protect our equipment. So this is giving people the rights to your property to service or protect their interest in their utility lines or gas lines, any of that items. An easement could also be something with a neighbor. An easement could be that Joe Smith and Sally Jones, they decided that they're going to have a common shared driveway. That easement continues to follow the property from owner to owner to owner because it's a recorded easement. So easements are things that give most cases right-of-ways or servicing to items on the property. If you see an easement, it's really important just to review it. We can always pull copies of the easement if needed. These are just common things that you're going to see. Our next item down here is a CCNRs. So CCNRs can be multiple things. CCNRs could mean that there's an HOA on the property. CCNRs could mean nothing. So if you look in if you have a property and you see a CCNR from 1942, and you know it's not in a HOA, we still have to disclose that those CCNRs are there, but 9 times out of 10, they're non-enforceable because back in the 1900s, a lot of items were put in there that are a violation of laws right now. So you can't discriminate, you can't restrict. If you want to see something funny, read CCNRs from in the early 1900s. They're pretty bad. They'll tell you the type of person that can live in the property, the type of sex, everything, which those don't hold up anymore, but because they're recorded documents, we have to disclose them. Now, if there's CCNRs and there's an HOA, this is another kind of red flag for us that, oh, we need to stop, we need to look and make sure we don't need to order HOA docs on the property for a transfer that needs to be done. So this is basically telling you the conditions, restrictions on the property, what can and can't be done on the property. Now, some of the CCNRs, they'll say things like you can't have chickens, you can't have goats and things, you can't have livestock in city limits. Those could potentially be enforced by the city if someone wants to enforce them. But when it comes to the type of demographics of the person, those are no longer valid documents.
Renee, I have a quick question here. Does escrow order the CCNRs?
If we need to order HOA, yes, we can order them. However, anytime there's an upfront payment, we cannot pay that upfront fee. We would either need the real estate agent to pay it and be reimbursed at the closing from the seller or have the seller pay that. But we would definitely facilitate and help with the ordering of any HOA docs that are needed for CCNRs. And in fact, I encourage you to let escrow do it. And the reason I say that is there's some HOAs that if someone other than the escrow company orders it, they don't issue a demand. And then when we go to order the demand, it's just as much as getting the HOA documents. So I definitely highly recommend checking with your escrow officer. And if you are working with an escrow officer and they refuse to order HOA docs for you, I would really consider trying to find one that will, because it's part of our job. And we order HOA docs all day long and we follow up and make sure they come in. So let us help you eliminate that part of your, some people put it on the real estate agent to do it. Let us help you do that. That's something that we should be doing for agents.
So if one agent gives the CCNRs, can they give that to escrow?
If they order the CCNRs, they can.
Her question is, can we give that to escrow, ones we get from other agent?
Can you give the CCNR, you're talking HOA docs or CCNRs? I guess that's the clarification.
I think it's CCNRs. Daksha, if you want to, both, she says.
So the CCNRs are recorded documents. So escrow would be pulling those documents. There would be no need to provide escrow with the CCNRs because we would have access to them just like anyone else. HOA docs, if the HOA docs are ordered and you already have them, you can definitely provide them to the escrow company. I have an agent who is adamant about ordering their own HOA docs. And I've told them over and over, like, let me help you with that so that your client's not paying this extra money for a demand, but they want to have that control, which is their choice to do. I just don't want your clients to have to pay extra money that they may not need to pay.
I have a question for you, Renee. Something that I get a question for often with HOA docs is, let's say I have like some agents that are just dominating some streets, some condo complexes, and they just sold the neighbor's house and they want to know, can I use the same HOA docs for my new sale for the neighbor's house? Are they allowed to do that? I have a lot of people asking me that.
I get that question a lot too. And my answer to that is, I would always refer to what your broker wants you to do in that case. Some brokers want you to order HOA docs for every single file. They want their own set of HOA docs. I have a client that I was saying, I have a development in downtown San Jose, and they have their HOA docs, and every so often they'll just update them. But we always have to get a demand. So the most important thing for escrow is that we need a demand specific for that unit. We can't use a demand for another unit because we need to make sure that we're transferring the right information and that we're making sure nothing is past due. So my first recommendation would always be to check with your broker to make sure your broker allows you to use HOA docs from another transaction. And then also checking the date on the HOA docs. If they're more than 6 months old, I would highly recommend not using them, ordering a new set, because you have new minutes, new newsletters, potentially new documents have been filed with the HOA. But most importantly, the demand. We want to make sure that we have the demand for the correct unit.
Got it. Thank you, Renee.
Renee, I had a question about the CCNRs. So if there is something in the CCNRs that seems outdated or potentially illegal, who should we direct our questions to clarify if those terms could be enforced? Would it be escrow, our broker, or paralegal?
You could check with escrow. We can determine. I mean, we're not going to have the final say. The county is going to have the final say, or who's ever trying to enforce them. The rule of thumb is if there's no HOA, it's really hard to enforce CCNRs. There's no one really managing them. If it's within an HOA, then the HOA would be the person we would refer you to contact. But you can always check with escrow and have us look it over to try to help you determine, yeah, this wording isn't going to fall. Well, these ones may potentially still fall. And we can always reach out to our title officer as well to check with them to see if they have any feedback that we could provide to you.
Got it. Okay. And these are also properties without HOA. For example, I sold a property in Concord, kind of in the farmland, and some of the CCNRs has some very discriminatory, lines in there. And so I just wanted to make sure I know if I had questions about that, would I check with the escrow first, and then who has the final say on what can be enforced and what cannot?
Yeah, and just know anything discriminatory is not enforceable anymore. I had one where it said you couldn't be of a certain race, you couldn't be of a certain religion, you couldn't have more than 3 kids. Like those things, those cannot be enforced. Like those are federal restrictions. Those are federal law will prohibit those from being enforced. And if somebody's trying to enforce them, then they could potentially be sued for that.
Got it. Thank you.
So also this top part, which isn't marked right here, it's going to talk about if there's any HOA. So it's going to help us determine if there is a particular HOA. It's going to tell us the HOA's name. I don't see the phone number. The phone number, I think this is maybe from the past. They used to put them on there, but we don't put phone numbers on here anymore because management companies are always changing. If you're trying to find a management company, always check with your escrow officer because we 9 times out of 10 can locate the HOA in the management company. But the other place that I found that is an easy place to find a management company is the Secretary of State. You can go to the Secretary of State's website, type in the name of the development under businesses, and it should tell you who manages that. So the next item on the prelim is deed of trust. In this particular case, our owner has one deed of trust for $550,000. The loan was sold to a new lender, which is it happens all the time. Lenders sell their loans and they just recorded a transfer assignment. But this particular owner is delinquent on their mortgage and a notice of default has been filed against the property. So first thing you're always going to see is the deed of trust, if it's ever assigned, and then if it's in default or potentially a sale date. So if, let's say, a sale date, you're working with a foreclosure and a sale date has been filed, there would actually be another one under here that's a notice of sale under terms of said deed of trust, and then it will show you the sale date. If you see a notice of default, I would highly recommend reaching out to the escrow officer to start working on ordering your payoff demand as soon as possible, because some of those payoff demands can take a full 30 days to get, because we have to deal with trustees, and then they have to deal with attorneys and all of that stuff. So if you know you're dealing with a property that has that, it's really important that we start working on those demands right away, especially if you're going to get an all cash offer, because sometimes you get an all cash offer to close in 10 days and we have to deal with a notice of sale or notice of default. There's a very good likelihood we're not going to be able to close within 10 days because it's going to take time to get those demands. It is escrow's responsibility to order all demands. So if your client says, oh, I have a copy of my payoff demand, that's great. We would love to have it to help provide an estimated statement, but they just need to know that it is our duty and our responsibility to actually get the demand issued to our company. We know everyone wants to be helpful, but there are some legal things, and we need to make sure that we just know that it came from the correct source. Not that we don't trust everybody, but there are unfortunately some strange people out there that try to pull things past, and we don't want a buyer to have any reason for their property to be hindered by that. If your client has an equity line, it'll also show as a deed of trust, but underneath it will say that it's an equity line. Sometimes people have equity lines, it'll show up on here and they're like, well, I don't owe anything on that. I don't use that. They may not use it, but it has never been released from their property. If you're looking at a prelim report and your client says I owe my property free and clear, but you see 3 mortgages on there and they tell you already paid those off, it's easy that they could have been paid off. They just never got released. And it's escrow's duty and responsibility to help get those releases, sometimes with the help of the owner, but we have to make sure that we're getting releases if it's been paid off. Item number 10 is abstracted judgment. So this particular seller has a judgment against them in a court. And so this tells us that we need to get a payoff demand for that abstract of judgment because it has to be paid through our transaction. It's really important to know that if a client says, oh, I already paid that, I don't know why it's showing up. They may have paid it, but it may have never been released. They may have the release. I would say 50% of the time when I'm talking to somebody about an abstracted judgment and they have already paid it, they have the release sitting in their file. They just didn't know that it needed to be recorded. No problem. Give us that release and we'll get it recorded for you. So anytime that's just a judgment is something owed by the seller or the borrower on the property that has to be cleared in order for us to clear the title of the property.
Renee, I just wanted to let you know you go into such great detail, which is so appreciated, but we just have about 10 minutes left.
Okay, thank you. We're almost done anyways. So the next item is a court order. This one's basically saying that they have some sort of support order. Could be child support, spousal support. No problem. We order that. We get that. If it needs to be paid, we'll take care of paying that. Tax lien. A tax lien is money owed to the IRS and to the state. I'm just going to put this out there just for an FYI because this just happened to me this week. If your client tells you that they have a tax lien and it does not show on the preliminary title report, let's talk about it. I unfortunately had a transaction that got delayed for 3 days because the seller knew that they had an IRS lien and it hadn't been recorded and was recorded 2 days before we closed our transaction, which delayed the closing until we could get a demand. So if you know your client says to you in conversation they owe a tax lien, let's let's talk about it and figure out what we can do to make sure that we don't have a delayed closing. Luckily, we got the demand. Never in my life have I got an IRS demand in one day. I don't know how it happened. The stars were aligned. Mechanics lien. Mechanics lien is anything that was done for work on a property. Mechanics lien is filed by the contractor, subcontractor, or person that performed the work and did not get paid. Mechanics liens can show up and your client doesn't know about them. We can always, it's a whole nother conversation, but we can always bond around a mechanics lien, which will remove it from title, and your client is able to work on get the lien released. Anytime you see item number 15 where it says we need a statement of information, if you're working with Fidelity Title Company, we send your clients a secure package in the beginning of our transaction, which they're able to give us that information so we can clear their name. So it's really important that we get the buyer's information, the seller information ahead of time so that we're able to clear their name for any potential liens that may show up. That's more of a common name. So if you have like a Joe Smith, obviously we're not going to put every single lien for Joe Smith on title. We're going to make sure we're only dealing with what we need to. We always run our buyers. So we're also going to ask for the same information for the buyers. We're going to ask them to complete a statement of information. This information is confidential. It's just making sure that we're not dealing with anything that can hinder the lender's lien position in the property. Our next section talks just about notes. These are all just informational notes. It has really nothing to do with the title insurance we're going to issue. The one thing we do make sure is aware is that if the property is being purchased for the distribution, manufacturing of sale of marijuana, 9 times out of 10, we cannot insure those transactions. If you are working with those type of transactions, really reach out to your escrow officer before going any further, because I don't know of any title company that will insure those. The next section talks about transfer tax. Note 2, really, if there's any transfer tax that's due on the property, it's going to be based on what is restricted in that county. Transfer tax is based on the sales amount. This number 5 is just letting you know that we are going to insure the property. We're going to issue the 116.2 comprehensive endorsement, which ensures the common street address for the land and not the mailing address. It's really important because people always want that zip code. And then number 8, it's always a note. We always make sure, we always ask the seller, make sure the legal description is correct on the property, especially when we're dealing with those condos. We want to make sure that we're having the seller help us make sure that any parking spaces or storage spaces are on there. And if they're incorrect, to let us know right away. And then number 9 is just a disclosure as well. It's just letting you know that we do require documents to be executed by a company employee or approved notary of our company. We can't just send docs out with any notary to be approved. We always give a wire fraud alert. Always tell the customer, call before you wire, verify. It's really important nowadays. We still see it. It's getting more advanced wire fraud. So all of our prelims will have a wire fraud alert in there for the clients. Your parcel map, the parcel map is always going to be included. Unfortunately, it's reduced in size, so it's kind of sometimes hard to read. We always let everybody know it's not a survey. Some people think it is a survey. We don't go survey the land. It's going to show you the subdivision, the recorded map, book and page. So if you ever want to go to the county to pull it, you can definitely pull it based on this information. That information is also included down here. We're always going to have an arrow. The arrow is going to point to the unit or the piece of land in question. It's always going to include the lot number, the parcel number, which is so small, it's really hard to read, and then the dimensions of the property. So we have this. We can also do, if you want, a color-coded map, which will show you any easements on the property. It's not something we do on every single file. So if you want a color-coded map, just let your escrow officer know, and they can get that for you. Depending on the complexity of it, it only takes a day or two. And I highly recommend that if you want, if you have a big piece of land, to get that color-coded map. And that's it. You guys have any other questions?
Thank you. And I apologize. I did not update
Okay.
your name on this
It's
PowerPoint.
okay.
However, I left Renee's contact information in the chat box. If you guys ever have any questions, please use her as a resource. We are here to be a resource to you, and our ultimate goal is to partner up with you in business. So I recommend all of you guys putting Renee in your contact list, just in case you guys have any questions. She's always available and always more than willing to help us out. So you've been amazing here today, Renee. Thank you for your time. I know how busy you are. So for you to give us this time and education is really appreciated. And let me see if I have any more questions here for you. I have one more question. So if you have a color-coded map, hold on, I just lost this.
Oh, sorry.
If you have a color-coded map, do we get another revision of the prelim report?
Yes. Anytime we would, well, actually, no, I apologize. You would not get another prelim because the color-coded map would be separate. It would just be a separate document we would send to you.
Thank you.
And one thing too on the prelim, just so you guys know, when you get a prelim and you see blue links in them, if you click on the blue links, it'll actually pull up the document that's being referenced. That's called a hyperlink or a ePre. So you're able to click on it and actually view the particular document in question.
Okay, I have one other question here. If the grant deeds grants to A and B, husband and wife, what does it mean? I don't know if you want to explain your question, Jenny, a little more.
I mean, does it mean joint tenant or married something? There's several kinds for husband and wife. Do they just write like this, or they need to specify for the title company?
You would need to specify. There's different ways to hold title. We would always match what's on the lender documents. But if you need, we have a form we can send to your buyer, which will explain the different ways to hold title. I would never, ever recommend someone just take title husband and wife. You always want to have a vesting, whether it's community property, joint tenants, tenants in common, or in a trust. And the reason I say it's so important is because if something was to happen and you don't have a vesting, you're going to have to deal with probate.
Yeah, because I think I saw one of this grant deed written like this. So if that happens, so we don't know what it means. So
Right.
I just don't understand why title company did that at the beginning, not specify. So
Yeah, they should. And if it's not done, you could always go back to them and ask them to do a correction deed for your client, because they should have husband and wife with some sort of vesting.
Okay, thank you.
Renee?
Yeah.
I think if you go 3 slides back, number 6, it really was a misprint because it was to ensure it was correct, but it was written to ensure it was incorrect.
Yeah, that's correct. We probably should change that.
So I have one more question here for you. What do we do in case of single unmarried man as a buyer? How do they vest because they are single?
So the question you want to ask your buyer is, you want to ask your buyer, have you ever been married, or have you been married? Single is a person who's never been married. An unmarried person is somebody who's been married in the past. Nothing needs to be done. And it really is just a formality, you know, that's just the rule of thumb we use. A single person is somebody not married. Unmarried has been married and no longer married. But a single person can do unmarried, an unmarried person can do single. Nothing needs to be done because they're sole and separate by themselves.
Thank you. All right, well, thank you guys all for joining us here today. It looks like we don't have any other questions coming in. So thank you all for your time. And again, reach out to us anytime that we could be a resource to you. Thank you.
Thanks, everybody. Have a great rest of the week.
Bye, Renee. Thank you.
Bye.